The topic of this talk really goes to the heart of the acknowledgement of country that we started the meeting with. I mean, these can sometimes be fairly sort of ritual statements, but this isn't ritual, this is real, and it goes to the core of what I want to talk about today, and the role of the law in dispossession and violence and so on. It's a huge topic, and I want to focus on three themes, basically touching on three themes in some senses, in sort of hope that the discussion can flesh some of it out. But the three things I'm looking at really raise some of the more important theoretical and strategic questions for socialists and activists about how we approach the whole question of the law and respond to the police and so on. And there's three things basically this. Firstly is the rule of law. We're often told, certainly if you go to a law school, that the rule of law is a good thing, that it sits neutrally above the top of society, that it gives everybody equal rights and so on. What I'm going to argue instead is that we need to understand the rule in a fundamentally different way. The rule of law essentially is the rule of capital and the economic and social relationships within it. And it serves both to enforce and legitimate these relationships. And while I'm going to be focusing on criminal law and policing, this clearly applies to other areas of law such as land law and so on, which I'll touch on as we go through. The second thing I want to look at is how the body of criminal and other forms of law which emerged during the development of capitalism in Britain between the 16th and 18th centuries, how that body of law essentially was transported to Australia with the convicts through the processes of colonisation and was shaped in a particular way, clearly playing a central role in the dispossession of Indigenous peoples, and it's generated and enforced ongoing structural violence against Indigenous peoples. And the third thing I want to look at, which is directly related to the second, is the role of the police in this process. Firstly, I want to look at them as the enforcers and the perpetrators, enforcers of law and the perpetrators of violence, lawfully or unlawfully. And this reflects their fundamental role in maintaining social order rather than protecting the interests of ordinary people. But also, and this is something which is often neglected, it reflects the important role the police play in interpreting the law and actually creating the law themselves on the streets to make decisions about who to police, who not to police, something which they can do with relative impunity and mostly very little accountability. Okay, so the first thing I want to look at then is the evolution, if you like, of the law during the transition from feudalism to capitalism, during the period from the 16th to the 18th centuries. Now, this was a very drawn-out, complex set of processes, and I really wanted to just pull out two key dynamics which Marx identified when he was writing Capital, his great economic work. The first of these was the enclosure and privatisation of land, the transfer of land from the huge feudal estates into private ownership for private production. And this represented, this reflected a broader shift to private ownership of the means of production as capitalism becomes the dominant social order. But to give you a sense of the scale of this, between 1604 and 1615, over 5,000 enclosure bills went through the Parliament in the UK, enabling over a fifth the total area of England to be enclosed during that period. Now, in Capital, the second overlapping dimension of this is the growth of urban centres, based largely on the back of a layer of working poor who had been uprooted during these processes of enclosure, who'd been driven off the land, who'd been separated from their traditional means of production, had nothing to survive on apart from their ability to sell their labour and so on. In other words, the very early beginnings of what we'd understand now to be a modern working class. And what this did was it created, apart from anything else, just created a large mass of beggars and wanderers who got generally described under the term of vagrants. And this term vagrancy I'm going to come back to several times during this talk. This whole notion of vagrancy is effectively talking about the dispossessed and the landless as a result of these processes that Marx describes. Now, in Capital Volume 1, Marx emphasised how in the early phases of this transition, which he characterised as a period of primitive accumulation, the need to discipline this nascent working class meant that criminal offences such as vagrancy and begging were punished with extreme brutality. Now, he gives a whole page of examples in Capital, which I haven't got time, obviously, to read out, but I'll just read one. This is during the period of James I from 1603 to 1625. Anyone wandering about and begging is declared a rogue and a vagabond. Justices of the peace in petty sessions are authorised to have them publicly whipped, and for the first offence to imprison them for 6 months, for the second for 2 years. Whilst in prison they are to be whipped as much as often as the justices of the peace think fit. Incorrigible and dangerous rogues are to be branded with an R on the left shoulder and set to hard labour, and if they are caught begging again, to be executed without mercy. So pretty heavy stuff towards the homeless, essentially, is what we're talking about in this period. And Marx goes on to comment that thus were the agricultural people first forcibly expropriated from the soil, driven from their homes, turned into vagabonds, and then whipped, branded, tortured by laws grotesquely terrible, into the discipline necessary for the wage system. Now, the 17th, as this period evolves, the 17th and 18th period, 17th and 18th centuries, becomes a period of immense social unrest in these developing urban centres. In fact, the period 1695 to 1840, generally amongst historians of the period, has been dubbed as the Riot Era. And during this period, the law itself takes a very brutal, particularly brutal turn. And there are two key pieces of legislation, or sets of legislation, which underpin this. The first was the Riot Act of 1714, which made it a capital offence, in other words, you could be hanged, if you did not disperse within an hour of the Riot Act being read. Offences such as affray, which still exist and widely used in New South Wales today, were sentenced at large, meaning that they could be any sentence that the magistrate decided you should have. There was no limit to the sentencing that was available to them. The second set of pieces of legislation was collectively known as the Black Act in 1723, which introduced over a period of 4 or 5 years between 200 and 250 capital offences, covering things such as trespass, hunting, and poaching, etc. In other words, basically the crimes of the hungry who have been dispossessed going back to hunt on their lands and claim some legitimate possession of those lands. Obviously sounds very familiar in the Australian context. And one of the main legal historians of the period commented on this. He said, "There is hardly a criminal act which did not come within the provisions of the Black Act. Offences against public order, against the administration of criminal justice, against property, against the person, malicious injuries to property, all came under this statute and were punishable by death. Thus the Act constituted in itself a complete and extreme severe criminal code." And E.P. Thompson, the Marxist historian who's written the most about this period, or certainly about the Black Act, said, "The Black Act was an astonishing example of legislative overkill. It became an original charter of death for 18th century legislators. Together with the Riot Act, it established an armoury of sanctions to be used in times of necessity against disturbance, and it also provided a model for subsequent terrorist legislation against disaffected Highlanders, Irish agrarian rebels and English smugglers." And so what you have during the 18th century, and on the back of these two pieces of legislation and the sort of political atmosphere that sort of engendered them, is what's broadly understood to be a reign of terror. And this was exemplified by the scale of public executions. At Tyburn in London, and for those of you who know Tyburn is where Marble Arch is now, on the corner of Hyde Park. At Tyburn in London, there were routine public executions. Between 1703 and 1772, 1,242 people were hanged in public. Over half of the people who were hanged were recorded as having their occupations as apprentices or artisans. Parallel to this, and sort of coming out of this, you see also the emergence of a burgeoning prison population and an ideological equation amongst the sort of the leading politicians of the day, essentially between the rowdy London working classes and the urban poor, with this whole concept of a criminal class. And there are actually sort of attempts to document and quantify this, and figures such as 115,000 in London alone by the end of the 18th century is something which is accepted as the sort of norm, if you like, of the way in which policy towards the working poor was developed. But what Marx also emphasised in Capital was that despite the brutality of this era, as capitalism developed, force alone wasn't capable of maintaining social order. More important was the nature of capitalist production itself, in requiring routine compliance and the acceptance of more broadly of capitalist ideology. And he writes in Capital in this sort of same section, he says, "The dull compulsion of economic relations completes the subjection of the labourer to the capitalist, Direct force outside economic conditions is of course still used, but only exceptionally in the ordinary run of things. The labourer can be left to the natural order of production. In other words, to his dependence on capital, a dependence springing from and guaranteed in perpetuity by the conditions of production themselves. It is otherwise during the historic genesis of capitalist production. So what he's talking about here is a period by the sort of 17th, 18th century where capitalism is normalised, it's the dominant form of economic and social and political life, and the law starts to sort of, an adjustment starts to be made in the law accordingly. So at the end of the 18th century, you start to see a retreat from what was known as the Bloody Code, particularly around the Black Acts. You see the introduction of transportation to the colonies in Australia. So between 1788 and 1868, something like 160,000 people are transported here, but over 80% of those were for property offences for which people previously were being executed over the previous 100 years or so. And what you also see, and this is important for what I'm about to go on to, is the creation of centralised police forces at the same time. In 1829, the London Metropolitan Police Force is formed. Later in 1862, very much modelled on the London model, the police force in New South Wales is established. So these developments provide the context for the colonisation of Australia and the implantation of a specifically capitalist economic social relations and their sustaining legal structures. Now the first settlements initiated, or the first colonial settlements initiated a period of primitive accumulation with some similarities to those which Marx described in Volume 1 of Capital. In relation to the convicts themselves, it was very much a carrot and stick exercise, while the early period of the colony, up to about the 1840s and 1850s, was a particularly brutal period of military rule. For convicts themselves, there was also the possibility through their compliance of shifting to free labour, private ownership and a degree of social mobility. Indeed, by the time the New South Wales Police Force was formed in 1862, over a third of the existing police officers were ex-convicts. We might get back onto that. Now, the main ideological device used to but the defining feature of settler colonialism was the seizure of land and its transformation through processes quite similar to enclosure of the land into a privately owned resource for capitalist production and extraction. Now, the main ideological device for this was used to legitimate this was the concept of improvement as advanced by philosophers such as the philosopher John Locke. In the world of Locke and the sort of dominant philosophers for the time, land that was not being improved, in other words, used for capitalist production and wasn't privately owned, was deemed vacant and could legitimately be seized and exploited with the full authority of British and colonial law. I mean, people talk about terra nullius in operation. Actually, terra nullius doesn't start to come into operation until the 1830s and 1840s as a legal concept. This is underpinning, so it's the legitimacy of seizing the land which underpins this. Now, this right to violent colonisation, which was claimed by all the European colonial powers during the period. And it was summed up in a tome called The Law of Nations in 1758 by Amédée Vattel, who's regarded as one of the founding fathers of international law. And he says this: "The cultivation of the soil deserves the attention of the government, not only on account of the invaluable advantages that flow from it, but from it being an obligation imposed by nature on mankind. Those nations who inhabit fertile countries but disdain to cultivate their lands are wanting to themselves, are injurious to all their neighbours, and deserve to be extirpated as savages and pernicious beasts. There are others who, to avoid labour, choose only to live by hunting and their flocks. Those who still pursue this idle mode of life usurp more extensive territories and with a reasonable share of labour they have occasion for, and have therefore no reason to complain if other nations more industrious and closely confined come to take possession of part of their lands." And so you see very clearly that there's two dynamics at play here. First, there's the immediate transplantation into Australia of a set of legal, economic and social institutions. But secondly, this is part of the global period, the early period of sort of imperial colonial expansion and the legitimisation of seizing land from what we now understand to be the Third World or colonised world. Now, this initial process of land seizure in Australia, as I'm sure many of you know, was an incredibly violent process which took place and spread over the period of roughly 100 years. It involved frontier and guerrilla wars. It involved specific massacres. Some of you will be aware of the project undertaken recently at the University of Newcastle, which sort of documented and mapped massacres in Australia. They're documenting over 438 massacres. In other words, incidents where more than 6 people are killed at the one time, leading to the deaths of over 10,500 people. There was very little protection from the law offered to Indigenous people during these processes, despite the fact that the Indigenous population were considered to be subjects of the Crown and therefore liable to what legal protections that might or might not involve. There were virtually no prosecutions arising from this period. Violence was considered legitimate for a range of broader ideological and political reasons, such as the need to maintain the security of colonial settlements, and also, quite frankly, for reprisals in situations where stock and so on may have been stolen. Also, there was very little acceptance of Aboriginal witnesses, despite again them being supposedly subject to the law of the land. William Wentworth, after whom the electorate of Wentworth in Sydney is named, probably fairly appropriately in lots of ways, when he was defending, he was an early lawyer in the colony. He defended a military officer accused of murdering an Aboriginal man in 1827, and he argued against Aboriginal witnesses on the basis that they were a set of natives 1 degree just above the beasts of the field, possessing no understanding beyond a confused notion of right and wrong. In such a state of barbarism and ignorance, they could not legally be sworn in any court of justice. And so, see very clearly, during this period that the racist dimension to the law is enforced in quite a ruthless and shameless, in lots of ways, shameless way. When there were prosecutions, and they were rare, they turned out to be the exceptions that proved the rule about the lack of interest in actually prosecuting themselves. Probably the best known case of this is Mile Creek in 1838 in New South Wales. 30 Aboriginal people were killed by largely a group of farmhands. 11 men were tried, and after 2 trials, eventually 7 men were hanged. But this led to such a public outcry that the governor at the time, Gibbs, actually put a moratorium on any further prosecutions. The second case, rather oddly, is Western Australia, where it's been documented between 1829, which is when the settlement first sort of started in Western Australia, the colonial settlement, and 1886, there were 29 prosecutions. 21 people were found guilty, but only 1 person was given the death penalty. During the same period, 25 Aboriginal people were executed in relation to similar offences. But the massacres were just the extreme form of systemic violence that we can identify during this period. For example, there's been very little recognition of the systemic sexual violence against Aboriginal women, the routine kidnapping, the sexual assaults, enforced prostitution and so on, which again sort of operated sort of within and above the law without anyone really taking any much notice of it. But as capitalism battered down in the colonies and what we can call the era of primitive accumulation in Australia ends, a range of separate systems of law were devised to isolate and control Indigenous people. And I'll just go through some of these, as I'm sure many of you will be familiar with them. Firstly, there were the various protection regimes which imposed total legal control over Aboriginal people. Linked to those often were the systems of unpaid labour, particularly in states like Western Australia. There was a network of reserves and missions. There were the forced removal and assimilation policies. There was the establishment of prison islands such as Palm Island off Townsville and Rottnest Island off Perth. There were special policing measures such as the use of neck chains, which had been banned during the convict era, but which were allowed to continue in relation to Aboriginals right up until the 1960s. And then there was the ongoing restrictions via the more recent Howard era intervention. Now, yeah. So on the back of that, what you're currently seeing is the current mass incarceration of Aboriginal people through aggressive law and order campaigns waged by state governments. Now, all of these mechanisms serve to maintain the separation of Indigenous peoples from their land, and in the process embedded and generated systemic racism, which in turn is sort of absorbed into the law and reproduced by the law in the way that the law is policed. So overall, what I'm going to argue is that the law operated in the interests of both the colonial and developing Australian ruling classes during the period of primitive accumulation, during a period of what we can call foundational structural violence, and then continues as a key mechanism through the measures I've just listed for ongoing structural violence, which is reflected in the marginalisation, poverty and criminalisation of many Indigenous communities. So I want to move on to the third point now, which is the question of the police and how, as part of their role in enforcing social order, police are central to the structural violence endured by Indigenous communities. Now, as I mentioned previously, centralised police forces, as we would recognise them now, were established in Britain in 1829, in London and in New South Wales in 1862. Now, the basic role of the police when they were formed, and you can look at the parliamentary debates at the time, both in Britain and here, was to ensure public order. This was, and this was quite explicit. The role of the police is about controlling public order, controlling the streets, looking after the sort of rowdy populations of the urban inner city, and so on. In New South Wales, the immediate trigger were riots on the goldfields out near Bathurst, where it was found impractical to sort of send the existing various police units to try and do it. And so there was this argument for a standard police force in New South Wales. But what New South Wales adopted during this period was essentially what had started to be developed in the UK, which is this whole notion of beat policing, of the police officer on the beat patrolling local areas which were considered, essentially working class areas, in some cases Aboriginal reserves, patrolling in order to maintain order. And what you see is the mobilisation of a whole range of offences which have their origins in that earlier really brutal period that I talk about. Vagrancy in particular. There were 4 vagrancy acts in the 19th century in New South Wales, in 1835, 1851, 1901 and 1902. And more broadly, you see the offences, the enforcement of what are called summary offences or police offences, offences which the police deal with, which are dealt with by a magistrate, never get near to sort of judge and jury vision that people have what the legal system looks like. That applies to about 5% of cases. What you had was a sort of plethora of summary offences which the police were largely in control of. On top of vagrancy, there were specific offences such as consorting, drunkenness, obscene offensive behaviour, political protests, and other forms of political organising. Now, police were given the extensive powers that police were given to enforce these are reflected in New South Wales by what was aptly called the new 1901 Police Offences Act. I'll just read out a couple of the things which were criminal offences at the time and which gave the police the authority to essentially patrol urban areas like Redfern, Waterloo, Surrey Hills and so on. Washing clothes in a public fountain, beating a carpet, flying a kite or exposing a horse for sale in a public place, bathing in Sydney Cove or other waters within view of any wharf, street or public place between 6 and 8 p.m, keeping swine within 40 yards of a public place. This is my favourite. In a public place, obstructing, annoying or endangering a person by placing a flower pot in an upper window without sufficiently guarding it against falling, repairing any vehicle except in the case of an accident, playing any game, hawking or covering uncovered meat. So essentially these police offences covered a very wide gamut of just daily working class life in early 20th century colonial New South Wales. And this sets the pattern for how we must understand the way that policing operates. The police, well, there's obviously high-profile roles the police play in, tracking down murderers and so on. Overwhelmingly, as I said before, in well over 90% of cases, police are engaged in summary offences. If you took summary offences and drug laws, which can be summary or both, out of the whole system would be vacated overnight. Today. So still account, as I said, they still account for over 90% of caseload, but we've also seen a massive expansion of on-the-spot fines. So what this does is it gives the police in their day-to-day activities the capacity to arrest you, get you into a court on some relatively minor offence, get you into the network of criminal offending, get you into the whole system, get you a record and so on. And enable the police then to continue surveillance operations within these communities, within these targeted areas. So the police and summary offences that I'm talking about are enforced through a wide range of largely unaccountable discretionary police powers. And amongst other things, this enables widespread racial profiling. If you look at the statistics in New South Wales for police decisions about who to surveil under their unlawful suspect tracking management policy, that move on directions, stop and search, decisions to arrest, decisions whether to give bail, decisions to whether to give a charge or a fine, all highlight a staggeringly disproportionate number of Aboriginal targets, particularly in areas like Redfern and so on. And this pattern has been continuing for many years, has been highlighted for many years, and it has potentially fatal consequences, particularly when people are taken into police custody. The Royal Commission into Aboriginal Deaths in Custody, which sat from 1989 onwards, did a survey in 1990 of people in police custody at the time and showed that over 40% were in there for drunkenness or other good order offences, 2/3 for offences other than violence or property crime. Aboriginal people were detained at 27 times the rate of non-Aboriginal people, and less than half the cases were examined by the Commission had actually ever been sentenced in a court. And this accounted for a significant proportion of the deaths in custody, which the Royal Commission itself examined. And the pattern has continued today, and it continues. I'll just give two examples which people may be familiar with. There was the case in Palm Island in 2004, the death of Mulrunji in the police station at Palm Island. He was originally arrested for offensive language and conduct towards a police officer, dragged into the police station, and had his spleen and liver severed by the blows that he received. Tanya Day in Victoria, 2017, taken off a train in Victoria by railway police, supposedly for being drunk, died from a brain hemorrhage in police custody after basically being neglected and left in her cell to die, having had a severe blow to the head at some point between being arrested and ending up in the police cell. Which gets me on to really the question of police violence more specifically, which is, that crucially police powers are linked to their capacity to exercise violent, sometimes lethal force as part of the state's monopoly of force that it holds. New South Wales Police today are armed with guns, tasers, batons, equipped with bulletproof vests, essentially combat-level armoury that has been normalised over the past 40 years. We've seen the emergence of specialised heavily armed squads such as the Riot and Public Order Squad, you'll see turn up to even the most passive, small, innocuous demonstrations. They sort of turn up as if they're about to invade Poland or something, the way they sort of strut out of their vans in these situations. You see the way in which Hannah Thomas, the Greens candidate for Grayndler in the last federal election, was brutally assaulted by one of these officers at a protest in Bankstown, where she was the legal observer and had her eye socket smashed and possibly losing the sight in one eye. Now, the only restriction on this force is that it has to be used reasonably to exercise that power, particular power. But it's extremely difficult to monitor this, and police are rarely prosecuted about excessive use of force during the exercise of their powers. Even when there are really obvious cases, such as police being shot, people being shot by police or otherwise killed, convictions are very hard to obtain, or there are virtually no penalty. For example, in the case of the Kumanjay Walker, the officer eventually gets convicted and then put on the police talking circuit in New South Wales. Roberto Curti, who was a Brazilian student in Sydney, who was tripping at midnight and walking down George Street, chased by 7 police officers, tasered multiple times, had 2 cans of CS spray emptied into his eyes before he died. 4 officers eventually got prosecuted. Only 1 was convicted of common assault, and the magistrate gave him a conditional discharge with no record attached because the officer had suffered enough. Claire Noland, 95-year-old woman, more recently tasered to death by a police officer whose whose case was recently heard. When the prosecution appealed against the lenient sentence given to that police officer, the Supreme Court said no, the sentence was sufficient because it was a poor exercise of judgment. I mean, there are things living under rocks which would have judgment to know that you don't taser a 95-year-old woman with dementia and in a walking frame. Anyway, I want to wind up by returning to the question of public order and the police power to make law. This power is exercised in two specific ways. First, it's made just by straight-out lobbying. The Summary Offences Act, which currently operates in New South Wales, has its origins, although it's a separate act now, has its origins in the Summary Offences Act of 1970, which was introduced specifically to police and regulate protests against the Vietnam War. Robert Askin, Premier at the time, famously said, just run the bastards over, and the police sort of said, well, we can't. And so the laws were introduced to regulate protests, and those laws are still, to some extent, still operating today. But during the parliamentary debates, at the urging of police, ministers argued for stronger laws for controlling demonstrators, and others decried, and I'm quoting here, sit-ins, porno political behaviour, whatever that is, extremists, violently inclined minority, campus turmoil, and demonstrators, all of which has a very obvious current resonance. The current protest laws, as I've mentioned, are maintained through the 1988 Act and have been extended several times recently after police complaints they can't prevent certain types of protests. There are numerous other examples of the police lobbying for extended powers, for example, over the use of sniffer dogs, use of tasers and so on. I don't really have time to go into this much more, but clearly they are a very important political lobby in New South Wales. More routinely, though, it's the police power to interpret and enforce the law, to construct and target what they define as suspect communities that enable the class and racial dimensions of the law to operate. Okay, so I want to just, a couple of points in conclusion. Firstly, we need to understand that formal equality before the law shields the reality that law is integral to capitalism through systems of regulation and basic class rule, and that police play a central role in enforcing and shaping how that law works. This takes on particular forms in the context of settler colonialism and the specific legal and policing measures taken to police and regulate, if you like, the Indigenous communities. And while there are many demands for law reform that socialists would support, as a set of institutions, the law cannot be relied upon to facilitate fundamental social change. It's really important that socialists, political activists, social movements are able to connect the dots and not separate the issues of class, race and capitalism, which is the way in which which is one of the tendencies of modern politics to do. And while there have been numerous specific struggles and campaigns that we want to build around these questions, ultimately these need to be part of a broader struggle against capitalism and its legal systems in entirety.